You are all very welcome. And I'm very pleased to welcome you all to this event, which is to mark Refugee Week. The headline of the title tells you what it's all about: accommodating asylum seekers, barracks, barges and hotels, which is obviously a pressing contemporary issue. Obviously, this is Refugee Week. I would have much preferred it if we could have been talking about the really inspirational nature of the Refugee Convention as the centrepiece of post-war international human rights framework, the promise that every single individual, wherever they were from, would be entitled to basic fundamental human rights, and if they couldn't have it in their own country, another would offer it. There's nothing for me more inspiring in the whole panoply of international human rights than the Refugee Convention, the right to claim asylum, which, as we know, is under substantial threat both in principle and in practice. And we're looking at the practice, in particular in the way that asylum seekers are being treated in terms of their access to accommodation. We could also have been talking about the extraordinary courage and bravery and resilience of people who are forced from their homes to seek refuge elsewhere, and the enormous contribution that they've made to the life of our society, whether that's in its economy, its social, cultural life, and the great benefits that they bring to our society, its diversity, and the extraordinary life experiences that refugees have, that they share with us as lawyers or as campaigners, and obviously motivate us to want to work in this field and to challenge what, on any view, is the single most destructive and devastating sequence of legislative changes and policy changes that are currently fundamentally undermining those critical principles and the practical access to refugee protection. So that's by way of introduction. We aren't looking at all those things, but I thought it was important to mark them. We're instead going to focus on different aspects of the failure, what is obviously systemic failure in the processing of asylum claims. They say the system is broken. It's broken deliberately, it seems. It's a system that can function, but if it's got the political will and the resources to do so, and we've seen over the last period of time that essentially determination of asylum claims has all but been abandoned as the priority for this government, with consequences both in terms of backlog, which is well over 160,000, and then also in the processing of claims, so that you do have large numbers of people. It's estimated to be around 51,000 destitute asylum seekers currently accommodated in hotels. That's not a crisis in itself. The crisis is because of the failure of the government to actually operate the system effectively, and the costs that are obviously exponential lay firmly at their door. Who are responsible for these systemic failures, and not those who are seeking asylum in the United Kingdom. So this event is brought across team in Garden Court. We're multidisciplinary chambers. We cover a whole spectrum of areas of law, but for this seminar today, we have members of a public law, community care and immigration teams, and that is Greg Keeley, Ollie Persey, Georgie, are all members of Garden Court Chambers, but we're particularly pleased to be joined today by Joe Underwood from the organisation Shelter, which I'm sure you're all familiar with, and the brilliant work that they do, as well as to my far left. I'd like to be on that end, but I'm in the middle. That is Mr. Ravishaan Rahel Muthiah, who works now at JCWI but has an interesting past, which I'm sure he'll bring to contribute to his contribution. So we are going to, I think, more or less go in that order and start with Greg. Greg is an experienced practitioner. He has a wide-ranging practice but focuses on immigration law. He's been heavily involved in challenges to the use of barracks, both the initial judicial review to the use of that form of accommodation, and then in particular the subsequent civil actions that have followed, and he'll talk about what's happening with that litigation. And we know that that form of accommodation is likely to be utilised again And so it's important to learn the lessons of that particular way in which the Home Office sought to discharge their duties to accommodate asylum seekers. Great.
Okay, so what I wanted to do with this section is to talk about the legal challenges brought against the accommodation of asylum seekers in Napier and Penally, which some of you may have been involved in, and to see what lessons can be learned for challenging the placement of asylum seekers in novel or contingency accommodation going forward. The more I do this job, and I'm doing this job now for about 15 years, the more I end up saying that every bad idea has been had before. Usually the bad idea is a bit further in the past than this time, but I still think it's important to be able to learn the lessons that we've learned in the last 2 or 3 years of dealing with the barracks issue. So, how did this come to pass? Well, first of all, in March 2020, the Home Office stopped removing asylum support where claims have failed, and as the Home Office put it in their letter explaining their actions, no service users at all were leaving the accommodation. So in early September 2020, the Home Office started looking for extra HMO or hostel style accommodation because the existing estate was at capacity. Keen users of maths will see that is about 6 months after. They stopped allowing people to move through the estate, and you might think that it was inevitable that they were going to eventually fill it up and they were no longer going to have capacity given the long-running capacity issues that the estate has had. Nevertheless, that appears to be the first time they started looking at doing anything about it, which may have been the result that everything went so badly wrong. On the 12th and 13th of September, the Home Office took control of 2 ex-military barracks, Napier and Folkestone and Penally in Wales, to use as accommodation under Section 95. They were to be operated and run by Clear Springs Ready Homes, and by 20 September 2020, which seems to be within a fortnight of this idea having occurred to somebody, at a senior level anyway, these camps were both operational. Now, the first thing that I had to do was to identify who would go into these camps. And the Home Office did conduct an equality impact assessment in September 2020, which came up with some interesting responses. First of all, it found that as significant adjustments to the accommodation arrangements would be required, it was not considered practical for any individuals who require adjustments to be accommodated there. And that is because, one of the things you'd hear in the newspapers is, well, why are these people complaining about being accommodated in these barracks that are perfectly suitable for our brave soldiers? Well, they weren't suitable for accommodation of brave soldiers, that's why they weren't in use. And Napier in particular had been subject to a report that said it was largely unusable, and not very much work had been done to remedy that situation by the time it was being used. The Home Office didn't want to use hotel facilities that were then empty. Now, bear in mind, when I say hotels were empty, this is the COVID period. This is just before the second wave. There were loads and loads of empty hotels, but the Home Office didn't want to use them. Nigel Farage is turning up outside hotels complaining, in Pretty Bratel's constituency in particular, complaining that asylum seekers were getting too easy a ride. The IA, the Equality Impact Assessment repeatedly refers to the need for guidance on social distancing and self-isolation and for appropriate adjustments to on-site facilities. Despite the fact that the sleeping quarters are large dormitories, so you're putting 24, 25 people in Napier in the same room, then you're having them share bathroom facilities with 14 other people, and then you're also having them all eat together. So the idea that there was going to be social distancing is stunning, really, and it really would take somebody quite senior in the Home Office to think that was a good idea. So, just to look back at exactly when this happened, September 2020, this is the point they decide it's a good idea that they should put all of these people living together in the same room. At that point, just to be clear, it was very much known that this was an airborne virus that was killing a lot of people. Anyway, at least the Home Office acknowledged that accommodation would be unsuitable for many people in practice, and they did have a policy for dealing with that. They said only single males would be suitable, and it would be particularly unsuitable for somebody who was had been subjected to torture, rape, or serious forms of psychological, physical, or sexual violence, as well as people with mental health issues, where there was a risk of suicide or self-harm, or people with infectious communicable diseases. And of course, there was no particularly good way of determining that. This is where people were held in Penally. And you'll see there that the social distancing facilities aren't maybe what you might hope for. How did they screen for suitability? Well, they did it by checking screening interviews, Not an ideal way of detecting if somebody has COVID or tuberculosis, I would say. At the ASF1, which is a form people had to fill in relation to their asylum claims, checking the Home Office's database. So had you already told them, in writing perhaps, that you were unsuitable for accommodation in this place that they hadn't been accommodating people in previously, or in any supporting correspondence. Now, a number of obvious things arising from this. One is, this just isn't going to get the information out that they say is relevant. Two, there's no procedure here for people who have already been transferred to explain, you've made a mistake here. You know, there's information about me that you don't know, you haven't known previously, and I'm totally unsuitable for this accommodation. There was no procedure for that at all. And the third thing is, of course, that there are certain categories of vulnerable people, for example, victims of trafficking, victims of sexual violence in particular, who often don't disclose immediately that they have that level of vulnerability. So this system, as set up, was just completely unfit for purpose. Issues of the barracks. So the barracks were not ideal accommodation, as it turned out. Conditions of both sets of barracks are very poor. They're totally COVID insecure, as that picture will have shown you. It's military-style accommodation. They're very isolated, and of course there were racist protesters. Now, to look into those conditions in a little bit more detail, in Napier, where the place is very isolated, there was a mile walk from the nearest shop. There was no street lighting in some places. There was very poor street lighting in others. Bear in mind, the place is surrounded by racist protesters threatening people. There's dormitory accommodation, sharing bathrooms for 14 people. The buildings are decrepit, paint peeling off the walls. A lack of privacy. You'll see a lot of the pictures in Napier, it looks almost like a hospital ward, because all of the people who were worried about catching COVID from each other and also wanted a bit of privacy were hanging bed sheets from the ceilings. Very limited healthcare available on site. One of the things I've seen in almost all of my cases of people who are really vulnerable is, I went to the doctor and told them about a bad dream, I went to the nurse and I told them all about my bad dreams, the fact that I was waking up screaming, etc., and they gave me some paracetamol. That's almost universally what happened. There was very little in the way of proper healthcare, or at least the availability of proper healthcare was very variable at different times. Several serious incidents of self-harm. I have one client who, bear in mind, they're supposed to screen people who are really vulnerable and at risk of self-harm out. I had one client who attempted suicide on site, was removed to hospital, and then they brought him back afterwards. Residents went on hunger strike in protest at the conditions. And then, of course, there's a serious fire on the 29th of January 2021, which happens in the context of quite a serious protest in relation to them all being detained. I'll get to that in a minute. Ceallaigh, very similar situation, isolated 2.5 miles to the nearest town. Again, very unsuitable dormitory-style accommodation, lack of really basic necessities, general lack of appropriate healthcare facilities. Residents, one thing people particularly complained about in Ceallaigh was having to queue outside for the toilets in the freezing rain on a hill, which is something that really bothered people. Of course, there was also a lack of adequate provision for religious facilities. There were curfews across both camps. When I say enforced by threat of homelessness, what I mean is they would say, well, if you don't come back by 10 o'clock, you're not coming back ever, maybe, or certainly tonight. So people would often be frightened of ending up being stuck outside, being stuck with the racist protesters or running into them. And there were quite a few people who, because of that, just didn't leave. They were afraid of what would happen. Military-style accommodation. It's hard to think of a worse place to put somebody fleeing persecution by the army than a military base surrounded by barbed wire where there are people shooting machine guns. But that is what happened in a lot of cases. There was no attempt to screen out the kinds of people who might have been particularly damaged by being accommodated in those kinds of circumstances. COVID-19, obviously, it's hard to overstate how stupid this was. The barracks were adopted as accommodation at the very beginning of the second wave. It was not like nobody knew at this stage. I mean, it was just when we were drafting the judicial reviews, it was incredible. We just having to put in like quotes about, this is an airborne virus. Putting the beds 2 meters apart when there's no ventilation in the room is not going to help. The Home Office at least had asked Public Health England. And I was always, why didn't Public Health England say this is a bad idea? It turns out Public Health England had specifically said, don't do this. This is a bad idea. It's totally unsuitable. And then in the end they said, well, if you are going to do it, here are a series of measures that you could take to improve things, which the Home Office dutifully didn't follow. On the 15th of January 2021 in Napier, there was obviously massive outbreaks, obviously. Outbreaks were described later by Justice Linden as inevitable. They were just told they couldn't leave. So there was no decision to formally detain anyone. They just locked the doors and put guards on them and said you can't leave because you're all in part of a bubble that has an infection in it. And they were kept in those circumstances in many cases for up to a month. The racist protesters is that this is the thing that if you talk to the clients they go on about most, because you had people outside screaming abuse at them, filming them, threatening them. There were occasionally physical assaults. I had one client who somebody tried to run him over in a car. In Penally also very similar circumstances. The Police and Crime Commissioner said it was a focal point for far-right activity, and of course it was. You put all of these asylum seekers in one place, you demonise them, and you also put them in a place where there are no adequate facilities set up for them to be properly supported, so they're putting pressure on local community resources as well. The ICIBI, I said that right first time, identified in various reports a series of problems. First of all, failure to consult local stakeholders. Now, I've mentioned this already, but you were talking about, I think in Penally there were 4 local GPs. 2 of them had just closed down when they moved these people into that area. It increased the number of people who need to go many fold. Bearing in mind that, of course, the thing you have to remember with asylum seekers is that you are, of necessity, almost always, almost by definition, dealing with a really vulnerable cohort who are going to need medical support more than average members of the population. There was an adequate assessment of the physical and mental health of those selected to be moved. We've covered that already. Poor communication with the camp residents. I mean, one of the things you get talking to the clients, and it makes it really hard to draft the grounds and draft the particulars of claims, is because they all say different stuff happened. I was told the curfew was 9. I was told the curfew was 10. I was told I couldn't leave. I was told I could leave, but I had to be back by 12. I was told I couldn't leave, and if I did, I was never going to be laid back. They were all told different things. It's hard to tell if the rules varied over time, because the Home Office says they didn't, or if different parts of the camps were enforcing different rules, or different security guards were enforcing different rules. Poor communication is the golden thread that runs through all of this. Poor employment practices by camp contractors, use of insecure means to share personal information, and dangerous shortcomings in the nature of the accommodation and poor experiences from residents, which I think is quite a good summary of what happened generally. So, what did everyone try and do about this? Well, the first thing we tried to do in the claims I was instructed anyway was judicial review claims. Many of us challenged those decisions by way of judicial review. In practice, I got very few JRs off the ground. Nearly all of them, by the time we got in a good PAP with decent evidence, they just pull it. They just transfer out, and did it in very many cases. In the few cases that they didn't, what would happen almost immediately was as soon as you brought the JR, they'd agree to transfer them out. Because the way to get people out was to show that they hadn't properly identified your client as vulnerable. And once your client's identified as vulnerable, they would just shift them out. So by the time you have a decent enough case, almost by necessity, they would cave. And as a result, they were mostly moved on then to the county court in KD for damages claims. NB and others was the one that did get off the ground. I think by the time it did, all of those guys have been transferred out as well. The findings of that were really damning, including that the use of this was in relation to Napier. The use of the barracks was contrary to the advice of the PHE, and even the minimal risk mitigation measures that the SSHD had said they would put in weren't implemented. An outbreak was in substance inevitable. The residents were exposed to an unacceptable fire risk, and you know that because there was an unacceptable fire. There was a huge fire which could have resulted in loss of life, and in fact resulted in many people having to sleep outside or sleep in quite unsafe situations for several days. The claim in respect to the reception directive and legitimate expectation failed. But Mr. Justice Linden was quite clear that the system of identifying vulnerable people fell below the fairly low standard required. And the particular context, of course, was one where the Secretary of State herself recognised that this was accommodation that would be unsuitable for many people. Mr. Justice Linden didn't find a breach of Articles 2, 3 or 8 on the particular facts before him, but did find that the 15 January 2021 instruction led to a breach of Article 5 and false imprisonment in those cases. So, civil claims. A large number of civil claims followed these of Penally and Napier. Typically in relation to Articles 3 and 8, false imprisonment, Article 5, Article 8 and Article 14, the Equality Act 2010, indirect discrimination. I think this is something Ollie's going to talk about in a bit more detail, how you can use the Equality Act in these claims and have been really useful in these claims. A breach of EU law. In practice, these have been settling where there's medical evidence that the Home Office got it wrong in allocating people in the first place, and the people have suffered as a result. And of course, many of these are personal injury claims as well. So it's been hugely expensive. So going forward, thinking about things like barges and thinking about things like about some of the other forms of novel accommodation. The novel accommodation thing I made up was, stupid places to put people would be another way of describing it. What can we learn going forward? Well, as I said at the beginning, a lot more I've been doing this job, the more I end up saying at talks like these that every bad idea has been had before. And in my experience, the Home Office makes all the same mistakes they made last time as well. And one thing we want to be looking at is selection criteria. I mean, the Home Office, you see from the tone of what's said that it's intended that these places that are being prepared will not be comfortable to be in. And for that reason, they identify particularly vulnerable categories of groups usually that are inappropriate. And we'll want to know, what are your systems now like? Have you got a good system for identifying vulnerable people? And more importantly, when you get it wrong, when you have somebody vulnerable put somewhere that they shouldn't have been put in the first place, have you got a good system for identifying those people and transferring them to better or more appropriate accommodation? Has the PSED been complied with? There's a really good case, I think it's on the slide somewhere, which I've quoted, which is Hoff in relation to PSED in relation to Napier. That was the decision of Mrs. Justice Leven, and she was absolutely clear that the Home Office had catastrophically failed to comply with the PSED in that particular case because of the failures to check on community support infrastructure. Because you're putting people into a situation where there is a real risk you're going to get these racist protests, and if you're going to do that, you should at least check if there's enough community support infrastructure for those people so that they don't create the pressures that increase the risk of those kinds of protests and that kind of ill treatment. It's really frightening what the experiences some of these people went through. In terms of bringing the claims, thinking about evidence, I mean, in my experience of doing them, the key evidence has always been evidence of vulnerability. These are the kinds of cases, I'm not talking about systemic challenges here, I'm talking about individual, granular, on the ground challenges, get my client out of this place challenges. What you need to do in those cases is you need to show why your client shouldn't be there in the first place, and that means vulnerability. Medical evidence in those cases is absolutely key. Detailed reps will often get you transferred, in my experience, and if not, they'll set a marker for the time you bring later. And of course, they're still doing up the bidding or other barges they're going to do, they're going to put together. We need to be looking, once that's complete, at what kind of facilities they have. If they're going to be having people attending doctors that are not on the barge or wherever, but are going to be in the port or some distance away, how long is it going to take to get people there? Is there going to be enough in the way of medical facilities? Are there going to be enough of the other kinds of facilities that will be required? Has the Secretary of State done her homework in terms of going and checking whether or not there are sufficient resources in the local community to support the huge number of people who are going to be, a huge number of vulnerable people who will need a lot of support that are going to be put through those areas. If you do bring those claims, they will generally need to be brought in the admin court, and the trick is bring them there, get your client moved, and then bring the claim in the county court or the KVD. And in many of the cases, I think urgency will be justified, but again, it'll be a question of how vulnerable your client is as to the degree of urgency that can justify being brought. So I think the lesson is these cases can be successful when you put the evidence together. The Home Office is going to make a lot of the mistakes that the Home Office has made in the past. There will be a lot of clients who need support, and we'll just have to do the best we can. Thank you.
Next, we're going to actually deal with the situation that Greg foreshadowed, and that is the impending use of barges. And as I said in introduction, we're very lucky to have Jo Underwood here to talk about that. Jo is a housing and public law solicitor, and she leads the strategic litigation team at Shelter. She's got a high-profile practice experience in cases concerning homelessness, the benefit cap, and out-of-area temporary housing placements. She does research and training, and the fascinating topic that she's going to focus on today, however, is the regulation and oversight of these barges, and how the health and safety regulations may impact on the legality of what's proposed by the Home Office, and and looking at it from that situation, because as I think she'll explain to us, shipping is heavily regulated, and there's a contrast with what's been happening in Scotland. But certainly I'm really interested in any Al Capone ways in which we can hold them to account, because they seem pretty impervious to human rights and fairness and justice. So if you've got a way to tie them in on regulatory framework, then it seems to me that that's a really important additional element to what we should be looking at when we're coming to think about how this form of proposed accommodation could be challenged.
Thank you. So yes, I am a housing and public law solicitor at Shelter, but I'm going to be largely talking about maritime law and shipping now. Shelter's had some advice from a city law firm that is an expert in shipping law, and so I'm going to share that with you now as we look at the government proposal. Well, the plan is going to happen to use a barge or barges as asylum accommodation, because I think it gives a really helpful and interesting context. I guess most of us will probably be experts in housing or immigration or asylum support law, but the maritime law does bring an interesting angle to it. Sorry, my hay fever has chosen this very minute to kick in. I don't know why. So I'm looking particularly at standards and safety in relation to maritime law, and I'm thinking particularly of the Bibby Stockholm, which you can see there. That's the barge that's currently in Falmouth, being refitted and refurbished, and is shortly to be brought to the port of Portland in Dorset, and it's proposed that they will house 500 adult male asylum seekers on board. We'll be looking at the legislation that may be relevant, regulatory landscape, a few issues about Portland Port itself. I feel like actually I need to just say that everything Greg highlighted that's gone wrong with Napier Barracks will probably go wrong in relation to the barge as well, so that's really helpful information. And then a short comparison with the cruise ships that we used in Scotland to house Ukrainian refugees. So I'm sharing my learning on shipping law. I'm not an expert, but I am becoming more knowledgeable. So there is a difference between the flag state legislation and where the vessel is docked. So the Bibby Stockholm that's coming to Portland flies the flag of Barbados. So it's registered there, it's bound to follow the laws of Barbados, and a vessel's flag determines the laws, regulations and standards that the vessel has to comply with. But it will be docked in English waters, so it also has to follow our domestic legislation, which is largely the specific requirements for the living conditions of those on boards. Where there's a conflict, they have to try and follow both or ask for an exemption from one or the other. I'm not sure how much that will be a problem, but it's just interesting context, I think. Turns out that the shipping industry is one of the most heavily regulated, and so I'm covering myself by saying, in addition to our usual framework of law that we would probably all reach for, there are some other acts and pieces of legislation, although not limited to this list, because there just seems to be a myriad of different pieces of legislation that will be relevant to the standards and safety on board the Bibby Stockholm. And this is interesting context as well, I think, and in particular what legislation applies and who's in charge. Because when there are so many players and when there are so many different pieces of legislation, there's huge potential for things to go wrong, for people to pass the buck, for one government department to say, I thought the other one was dealing with it, or I thought this contractor was dealing with it. So I think this is really helpful context and some really important things to look out for. The Merchant Shipping Act, I'm not going to go through all these in massive detail, I don't have time, I'm just really listing them here and you can have a look at them later. That's what gives effects to most international shipping conventions. Really important are the Portland Port General bylaws. They are largely to do with how the port is run, safety and security of the port. There's a maritime guidance note which identifies the domestic safety requirements applicable, which will include life-saving appliances and firefighting equipment. There's legislation about the accommodation, overcrowding and adequate space to sleep. There's health and safety regulations, And there's also the International Ship and Port Facility Security Code. So there's a number of different things at play here, all dealing with different aspects of life on board: safety, security, fire, accommodation, overcrowding, standards. So there's that whole kind of mishmash of things already happening. Added to that, there's a number of different bodies who are potentially in charge or oversee this. We're not really sure. The Home Office are at the bottom with a question mark, because it's not entirely clear what role they're going to play, other than contracting the vessel, contracting people to run it, and then who knows what ongoing involvement they'll have. There's the Maritime and Coast Guard Agency, which falls under the Department for Transport, and they produce legislation and guidance for ships. They inspect vessels. The Portland Harbour Authority is responsible for the management and running of the harbour. And Corporate Travel Management is the firm who manage the cruise ships in Scotland. The Home Office has contracted them to manage and run the Bibby Stockholm, but they are what they say on the tin. They're a corporate travel company. They organise business trips and travel for international businesses. Not really clear what in-depth knowledge they'll have of the issues arising from accommodating 500 asylum seekers on board a barge in very close quarters. So there's all those different people who are potentially involved. And then I think it also helps to look at some of the particular issues around Portland Port, which is described on its website as a thriving commercial port. And I've spoken to some people who, Shelter has an office in Dorset, spoken to some people who know the area, I've spoken to people who've worked in Portland Port before on boats, and it looks a bit like an airport, I guess, with that kind of, it's not a place where you can just walk freely without fear of kind of being run over by a massive lorry, or, there's cranes and shipping containers and lorries and vehicles everywhere. We don't know where the Bibby Stockholm will be berthed, but it's very likely that you would have to get, if you're on board, you'd have to get some kind of transport from that end of the port to the exit of the port. So although the Home Office say that people are free to come and go as they please, that's actually not going to be the case in practice. So it's likely you'll need transport from the boat to the harbour gate, and it's very likely you will need transport from the harbour gate to go into Portland or wherever it is you want to be. So if you look at the picture on the right there, apologies if you already know the layout, but I thought this was helpful, I didn't before. The port is in just off that causeway in the middle there on the right, where it says in Breakwater Fort, there's the port is there, so you need to travel along that causeway to get to Weymouth, which is where the major facilities are. There's a large supermarket there, doctors, dentists, that kind of thing. Facilities on Portland are pretty limited. And I think the nearest hospital is in Dorchester, which is so far away it isn't even on the map. But you get the point. It's going to be difficult to get to major facilities, and in fact, this boat, the Bibby Stockholm, was used before by the Dutch authorities to house asylum seekers, and very sadly, the gentleman on board, Rachid Abdel Salam, died because he had a heart condition and there wasn't sufficient medical care on board, and he couldn't get to anywhere quick enough to help him. So I don't know if the Home Office is learning those lessons from the past. They say in a fact sheet there will be access to medical provision on board, and they are concerned to make sure that the local GP doesn't get overwhelmed. That's all the information that the fact sheet on the Portland Port website gives us. We don't really know what that means in practice. So there's a whole load of issues to consider about Portland Port itself and how people will get on and off the boat and what kind of care and help will be available for them. So as I've said, access to the harbour there's a gate, it's restricted. It's likely you're going to need a photo ID or pass to get in. That's what the rule is at the moment. The port gates are locked at night, so if you're not back in time, who knows whether you'll be allowed back in. If you're asked to leave, so this comes onto the port rules, you have to stay away for 24 hours and you're only allowed back in with the specific written permission of the person who asked you to leave. So we don't know whether that's going to apply as well. These are in the Portland Port General Bylaws, if anyone is minded to read them. But actually I think all these things are really useful to know because it sheds a light on the reality of what it's going to be like living on board and living in this area. And like I say, it sounds very much like those issues that cropped up in Napier Barracks are going to arise again here. We don't really know who's going to be in charge of safety plans, thinking of particularly fire or emergencies. The port has a marine safety plan. The boat itself, the barge itself, should also have detailed emergency procedures, but we don't know who's going to be on board and who's going to be in charge. Will it be corporate travel management? Will it be people who know more about asylum support than they do? We don't know. The information given has been very sketchy. We don't know what security is going to be. Portland, as I understand it, is a very small community, and lots of people who live there have families, that go back years and years and years, and they're very anxious about this barge being docked in Portland. They're anxious that local services will be overwhelmed. We don't know how they're going to react, how the community is going to react. There's lots and lots of unanswered questions, so I'm sorry I'm breaking one of my own rules and raising more questions in a talk than I'm actually giving answers for. But that is the situation that the Home Office has left us in, really. Shelter is currently writing to the Home Office to ask for clarification on these issues, and if we get any information, then we'll be very happy to share that. Wrap through a bit, sorry, just because of time, but I'm happy to get questions afterwards as well. And just a very short comparison with the cruise ships that have been used in Scotland to house Ukrainian refugees. Actually, it turned out when I looked into it that the comparison isn't necessarily all that helpful. A cruise ship is a passenger vessel which has an engine and it operates at sea, so there are different regulations that apply to that than the barge, which is not a passenger vessel, even though it will have people on board, and it doesn't have an engine. So actually, cruise ships are subject to more onerous regulations. The comparison doesn't necessarily help us very much in challenges, I don't think. What was more informative was reading the Red Cross report, which I've just highlighted there, which highlighted, looked at the situation from Ukraine a year on, and in particular it was looking at the accommodation on the cruise ships, and was very strong that cruise ships are not appropriate. They're isolated, they don't support integration, there were no timescales for people on board, so it added to the stress they were already going under. And as we all know, the Home Office track record on processing asylum claims is not at all good, and we don't know how long they were on board the barge, and there was no forward thinking, no infrastructure to support them after they left. So that's actually quite a helpful report to have a look through. And just finally at the end there, I've included some links which you can look up later for helpful articles. I was looking into ships that have been used before, just different reports. The third one down actually is an article about the government's foray in the 80s into using a ship to accommodate asylum seekers, and it broke free from its moorings and ran aground. So that was the last time I'm not anything to do with this government, used a boat to house asylum seekers. And I've just put at the bottom there, just to flag this because it is a really interesting reading, a report by a prison inspector in 2005, because Portland has actually had a boat there before but used as a prison ship, HMP Weir. And there were, that report is actually really informative reading, and it was very scathing of the use of that boat, and it shut down shortly afterwards. And in fact, all the reports on using boats to house either prisoners or asylum seekers, the common denominator is they are really expensive to run. They're inappropriate for whoever is on board and hugely expensive because of the onerous nature of the maritime safety laws they have to comply with. That means the expense of running them greatly outweighs the benefits. So that was highlighted in that prison report and in other reading as well that I've highlighted. So I hope that helps a bit. It's quite useful for us, hopefully, as we think about how to respond to the use of barges, and I'm happy to take questions at the end.
Thank you very much, Jo. I'll be digging out my copy of the Merchant Shipping Act when I get home. And we're going to move on now to Ollie Persey's presentation. Ollie, you may know, practices in community care, administrative law and human rights law. He's in Chambers and Partners, a rising star. So I'll have to mention that because it's written down here. But congratulations.
Actually, legal 500, but
but you're going to find out why when he gives us the benefit of his wide-ranging experience, which in relevant areas that we're looking at today include age assessments, asylum support, welfare benefits, health and social care. And he has a particular expertise in representing children and children with disabilities, including children who are deaf. And in this context, as Greg indicated, what Ollie is going to focus on is the Equality Act 2010 and what scope that gives for challenging the use of these different forms, in particular looking at disability and race. And he'll also discuss how there are links between the public sector equality duty through indirect discrimination and reasonable adjustment claims. So, Ollie.
So I'm going to be doing a whistle-stop tour through the Equality Act in 12 minutes. So sorry if this is not the most comprehensive talk ever, but I will hopefully hit on some key points. And if you want more information about any of the stuff on this slide, you can instruct me. So consider this a sort of teaser. So broadly, why would you bother using the Equality Act if you've already got statutory duties under Section 95, etc.? Well, there are positive duties, particularly the reasonable adjustments duty in relation to disabled people. The inquiry duties inherent in Section 15, Section 20, and in particular Section 149, the public sector equality duty, supplement existing rationality review standards that are part of the asylum support statutory scheme. There's the opportunity for damages, and I say with a question mark, exclamation mark, reputational harm to the Home Office. Most defendants would be concerned about a finding of discrimination, query whether the Home Office is. But the inconvenience of going to trial on a discrimination claim is certainly added pressure because, as Greg mentioned, they tend to transfer afterwards, and it's very hard to get a discrimination claim struck out, even a very bad one. Not that I'm suggesting anyone here would run a very bad one, but the case law all suggests that discrimination claims go to trial apart from the most obvious cases because they're so fact sensitive, which adds pressure in your toolkit when negotiating settlement. So I just wanted to get through the technicality and the boring bits. Generally, looking at Section 29, you're a service provider if you're a public authority, and if it's not a service, but also but is a public function, that's caught by Section 29, subsection 6. People think that Equality Act claims should be brought in the county court. That's correct, but they can also be brought as a supplementary ground of claim to a public law ground in a judicial review, and that jurisdiction is specifically preserved by Section 113(3)(a). So that's quite small text, and that is the nuts and bolts of indirect discrimination. The good thing about discrimination claims is they're quite compartmentalised, as in you can break them down into little chunks. So you need a provision, criterion or practice, a PCP, that's pretty broadly defined, and it can include like an individual decision, informal policies, rules, pretty much everything is a PCP, but when thinking about framing them, try and be more specific if you possibly can. It is not defined anywhere in the statutory scheme, but the EHRC guidance, which I put on the screen, is hopefully helpful to explain just how broad a concept it is. Particular disadvantage, while the PCP must be the but-for cause of the disadvantage for the individual. And essentially, if you think about this as being indirect discrimination, it's on the face of it neutral, but it will disproportionately negatively affect a particular group. So a facially neutral provision that disproportionately disadvantages a particular group. And a classic example from another area of my practice, education law, would be school uniform policies. So if you have a ban on cornrows in school or afro hair, as we saw with the Ruby Williams case, it's not expressly targeted at a protected characteristic, but disproportionately certain racial groups will have that hairstyle. So facially neutral provision, disproportionate impact. You do need a comparator. I've not got time to go into the intricacies of what Section 23 requires as a comparator. You can instruct me. But once you've got through all of those elements, you get to what's called, you've established your prima facie case, and the burden shifts to the other side. So if you can tick all those boxes that I put on the screen, you're now into proportionate means of achieving a legitimate aim territory. And Section 136 of the Equality Act means the burden shifts, and it's on them. And the battleground for discrimination claims is often on justification. And I will speak to later why the public sector equality duty and trying to get evidence of PSED compliance is so important, because it's a really important factor when pushing for, to say that justification cannot be made out. Always in the background of an indirect discrimination claim under Section 19 is that you've got an Article 14 claim, and in many cases an Article 14 claim, which is under the Human Rights Act, brought to the Human Rights Act, Article 14 ECHR, may give you greater flexibility than a Section 19 discrimination claim. So if you are struggling to fit your discrimination into one of the protected characteristics in the Equality Act, you may want to consider Article 14 either in addition to or in substitution to your Section 19 ground. The reasonable adjustments duty is one of the disability-specific provisions in the Equality Act. There's also Section 15 of the Equality Act, which I do not have time to go through, which is discrimination arising as a consequence of disability, which is a form of indirect discrimination, which doesn't have the same strict comparator requirement. Now, reasonable adjustments duty, you have to evidence disability. You do not need a formal diagnosis for disability, but as Greg's mentioned, in all of these cases, medical evidence to establish vulnerability, GP letter, CAMS letter, whatever it might be, is very useful, and you should try and get the best and most cogent evidence that you possibly can. But if you cannot put a finger on a recognised condition or a formal diagnosis, as long as you've got cogent evidence of symptoms and interference with day-to-day life, that's going to be long-term, so in 12 months, even if you haven't reached that time frame yet. Don't think you can't run a disability ground. You can, potentially. So we're back to the next bit being PCP, saw that on the previous slide. Substantial disadvantage means more than merely trivial, so that's quite a low bar. The comparator requirement is less stringent in a reasonable adjustments claim, so it's persons who are not disabled, and the Supreme Court in Pooley adopted a fairly generous approach to that, which is, Pooley was a case around a bus provider had a first come, first served policy, so that wheelchair users couldn't necessarily get a wheelchair secure space on a bus. And the comparator there were disabled wheelchair users. So just having a disability, so persons who are not disabled, if you had a disability that wasn't wheelchair user, that didn't preclude you bringing a reasonable adjustment claim, even though the plain wording of the language might suggest that. Now, reasonable steps is essentially the battleground of a reasonable adjustments claim. And Rowley is really the best judgment on this, which is well worth reading. Mr. Justice Fordham does a really excellent, as you would expect, thorough analysis of the case law on the reasonable adjustments duty. And there are a number of factors in play, including practicability, cost, disruption, and the defendant's resource. Obviously, the nature and extent of the disadvantage is also relevant about what is reasonable as an adjustment. So it's a highly context-sensitive exercise. Context is king, as is many areas of discrimination law. There are two elements of the reasonable adjustments duty that are worth thinking about alongside this, which really feed into the point I'm going to make about the public sector equality duty, which is it has to be anticipatory and also continuing. So if it's an anticipatory duty, you have to think about it ahead of time. So the classic example is a wheelchair user rocks up at a shop and there's a step. If the shop does not have a ramp, they have not anticipated the needs of disabled people, they're in breach of the reasonable adjustments duty. They should have done that before the wheelchair user came anywhere near their shop. The continuing duty is engaged when actually you're meant to keep this under review. People's needs change. So that links into the inquiry duty, which is so helpful in the public sector equality duty. So what is the PSED? It applies to public authorities and those exercising public functions. It is a procedural duty, and you see so many times in responses, defendants running points that, oh, it makes no difference if they followed a procedural duty or not. It's just a procedural duty. It doesn't require you to do anything substantive. But important is bullet point 3. It's integral to establishing whether a prima facie case of indirect discrimination or whether reasonable steps have been taken. Because, crux of it is, if you have not considered all of the options in detail pursuant to your public sector equality duty, how can you evidence that what you're doing is necessary, which is one of the requirements for prima facie discrimination to be justified? PSED people also quite often think of it, oh, it's for big policy challenges. Oh, I'm not running a policy challenge, I'm running an individual case. PRETI is the authority which establishes individual decisions just as much, this is important, and just as relevant for the PSED. So the PSED, sorry, I'm going at a fairly hefty pace because of the number of slides I need to go through. It's a 3-part duty of eliminating discrimination, advancing equality of opportunity, and fostering good relations. They're 3 separate and distinct duties of due regard. They're not just a homogeneous blob of we considered the Equality Act. So what is due regard? Consideration of the equality's implications of your decision making. It's context sensitive about how extensive it is. So it's an irrationality standard, but what is a rational level of information to ascertain depends on the level of disadvantage and the complexity of the issues that you are looking at. You should be putting a decision maker pursuant to the duty of inquiry that is inherent in the PSED in a position to make an evidence-based and rational decision. As the EHRC says, it is about informed decision making, not about carrying out particular processes or producing particular documents. There are the bracking criteria, or criteria that are key to establishing whether the PSED have been breached, which have been approved by the Supreme Court in the case of HOTAC. So record keeping is a very important way of evidencing discharge. It is a bit like the reasonable adjustments duty. It's anticipatory and continuing. It is not a box ticking exercise, and it is specific rather than general regard. So I'm just going to, in the interest of time, drill down on the continuing duty part of this, because I think it's particularly important. If you have someone that's in asylum accommodation for a long period of time, and if you're mounting a systemic challenge, the continuing duty is really important because it contains a monitoring duty. So the Unison case was about employment tribunal fees, but the principles apply here. And there's also the case of DMA, which I'll come to in a little bit, which was specifically in this asylum support context. And the really important bit is the highlighted section at the bottom of my slides, which is essentially you're meant to be gathering an evidence base and keeping it under review to understand the impact of your decisions. And in DMA, it was put explicitly thus: there is a fundamental obstacle preventing the Secretary of State being able to have due regard to the need to eliminate discrimination, advance equality of opportunity, and foster good relations. It follows from a failure to undertake any form of monitoring of disabled people accessing the system. And PSED grounds are really effective because the Home Office is rubbish at monitoring. It's a really small unit in the Home Office, and they don't do their homework. They don't keep the receipts. So running a PSED ground is really helpful in addition to a substantive discrimination ground, because it is a colossal headache for them if they're going to be compliant with their duty of candour and cooperation to give you all the relevant information to show that they're being compliant. And if they fail to evidence discharge of the duty because they haven't got their systems in place to monitor either on an individual or a systemic level, then they're going to have difficulty justifying a prima facie case of discrimination. And that brings me to PSED and justification of discrimination. So it is well established, a line of authority from Cole in the Supreme Court to the High Court and other areas. Lady Justice Arden, as she then was in the Elias case, put it well. It is a salutary requirement and this provision must be seen as an integral and important part of mechanisms for ensuring the fulfilment of the aims of anti-discrimination legislation. This predated the 2010 Equality Act, but it was still the same duty. And this is Steph's case of Hussein, which applied the principle in Cole. The highlighted section is the really important bit. That the minister has failed to address his mind to the problem and how it may be mitigated or avoided. Whilst the question of justification may not logically depend on whether the minister has thought about it at the time, a minister who did not think about it is likely to be disadvantaged or disabled in demonstrating justification unless until he has properly thought about it. So how can you show it was necessary if you haven't thought about it? And the EHRC similarly reflects the same approach. So I just wanted to briefly sort of bring this all back to asylum and support accommodation. Greg's already mentioned the sort of risks of the far right attacking asylum seekers and how that impacts upon asylum support and the suitability and adequacy of asylum support. So there are exemptions to the Equality Act, including the PSED, where immigration functions are excised. Disability, the carve-outs are extremely limited, and race, they are more extensive, but not in relation to skin colour. So if the far right is predominantly, not exclusively, but skin colour is important to them. So if you are thinking about a PSED argument, you can use race in context and sort of the racist hostility that we're increasingly seeing around hotels. This was the article I've screenshotted there is in relation to what happened in Liverpool. But we've all seen growing evidence of hotels being targeted by the far right. That has to, in my view, factor into a public sector equality duty assessment around race. Supplement existing duties. I've already mentioned that intrinsic in many of the bread and butter, for want of a better term, statutory schemes that we rely upon when representing asylum seekers in accommodation challenges is a sort of risk and needs-based assessments. And reasonable adjustments duty, you can get really good outcomes by saying, look, well, not just reasonable adjustment duty, but other duties, by saying, look, you need to actually modify your provision criteria, how you apply your provision criterion or practice here, because if you're not going to be discriminatory, this accommodation needs to be better and meet their needs in X, Y, Z ways. And obviously, Section 95 is about destitution. If you suddenly get a massive, not massive, Equality Act damages are not massive, but if you get a substantial amount of money for an Equality Act breach, is that going to make you ineligible for Section 95? The position of the Home Office seems to be no, that they would disregard it. And if they adopted a different approach, I think that would be in itself disability discrimination or discrimination of another kind, depending on the protected characteristic. So that's all I have time for. Thank you very much.
Thank you, Ollie. So our next contribution is from Georgie, who I said is a barrister at Garden Court Chambers. She too has a wide-ranging practice in asylum, education, and community care and immigration, substantive immigration law. She has a judicial review practice focusing on complex asylum cases. One of her specialist areas is education, and she is going to speak to us about the position of education, access to education for those in asylum accommodation, and focusing particularly on a case that she was involved in where a family were moved from their accommodation in London with significant disruptive consequences for the child's education. And of course, it's important for us to bear in mind that children are often in these different forms of inferior accommodation, and their lives are often substantially impacted by the failure of the provisions that are made.
Thank you very much, Steph. So it is the longest day of the year. We don't have all evening, so I'm going to aim to make this the shortest of the presentations, as I know that Rav's got an incredible speech to give us afterwards. But so starting with the issue, we've heard from Greg how the Home Office's systemic failures and delays in processing claims has resulted in a growing number of these temporary, novel types of accommodation. But from the Home Office originally not using hotels, as of May 2023, there are 51,000 migrants being accommodated in hotels, although, as Joe said, 500 of those men might now go and live on a barge. But what are the conditions actually like in these hotels? 5-star? No. We have families with no facilities to cook hot meals. I represented a family where the mum had, well, they were excluded from the hotel because mum had bought a camping stove to heat up some soup because the children had contracted such bad dental problems that they couldn't eat solid food at the time. So food is an issue and diet remains poor in general. There's no space for play. So important in your development. Parents' poor mental health has a greater impact on children because of the overcrowding, and they're witnessing their parents' trauma in these incredibly close quarters. But one of the most significant deficits is the deficit in education provision. There's nowhere for kids to do their homework or online learning, and it's really difficult if siblings are in different key stages and they're all trying to do things either online or in a room where their parents are. That's what we're looking at when we're talking about children being accommodated in hotels. So I'm going to be looking at the findings of a recent case. I actually wasn't involved in it, but thank you anyway, Steph. The case was brought by the Public Law Project, Shelter and Dayton Pierce Glynn. Several of my colleagues in chambers did fight valiantly for the claimants, but I was not one of them. And it's following that judgment, deeply unfortunate outcome, several Afghan children and their families found themselves uprooted from London and were moved to Greater Manchester. So who were the claimants? They were people who'd come over from Afghanistan following the Taliban uprising in 2021, and they were provided with this kind of temporary bridging accommodation, not Section 95 accommodation, and you'll see why that's key. And it was only temporary until they were offered somewhere more permanent. So the claimants were accommodated in a Southwark hotel, but the hotel terminated their contract. Pandemic's coming to an end. They can start having holiday makers again, holiday makers in Southwark. The defendant then wanted to move all of the residents who had been in that hotel to new hotels, and 2 were proposed in Manchester. I haven't got a map like Joe did with Portland, but we know that's the other side of the country. And among the families, there were children, some teenage girls in particular, who were part of the claimants, who were preparing for their GCSEs. So they were going to lose their school place in London. There was no guarantee they would have a school place in Manchester. And some of the children who were offered guaranteed school places, those schools were 2 hours away from where these incredibly remote hotels were. So they were challenging the decision to offer the bridging accommodation in Manchester, and they were seeking orders that they remain in the London Borough of Southwark. So let's look at the duty the claimants tried to rely on. We're all familiar with the Section 55 duty, which obliges the Secretary of State for the Home Department to have regard to the welfare of children when executing her functions. But from subsection 2 there, and this became key in the case, she only has to have regard to safeguard and promote the welfare of children in relation to her immigration, asylum and nationality function. So it started quite positively, and here I cite from paragraph 91 of the judgment, which highlights Section 55 at its highest. So it requires the Secretary of State to consider the specific circumstances of each child, identify the principal needs of those children, and it's not merely a duty to safeguard, but it's to actively promote welfare. And it imposes an enhanced duty on the Secretary of State to be properly informed and consider all relevant information. So we look at that and we think, well, clearly she hasn't complied with that duty in sending these families with children to Manchester. But not so. The court found that this bridging accommodation wasn't within her immigration functions, and they wouldn't interpret it more widely. Bridging accommodation has nothing to do with immigration, asylum, or nationality. The court gave it those words their ordinary meaning and said so the Section 55 duty wasn't even engaged to begin with. All I can say there is this might not apply, and we hope and we would argue it doesn't apply to Section 95 accommodation if it was expressly Section 95 accommodation, because that is an immigration function provided by the Secretary of State for the Home Department, as opposed to this obscure bridging accommodation. The second difficulty with this judgment is that it created a very low bar for the discharge of this duty. So the High Court said that even if the Secretary of State had owed the Section 55 duty, it was sufficient that she'd given the local authority, so Manchester, an opportunity to raise concerns about the number of school-age children. I'm not going to go through them, but you should get the slides. And this is a summary of the inquiries which the defendant made, and they're not extensive. And Manchester did voice concern about whether they would be able to provide school places for all of the children that were coming. But at paragraph 117 of the judgment, the court said, well, before we even consider Section 55, we need to ask ourselves, could no reasonable authority have been satisfied on the basis of these inquiries that it possessed the information necessary for its decision about whether to offer the claimants substitute bridging accommodation in Manchester. So it's an incredibly low bar for the Secretary of State to meet, even if Section 55 had been engaged. The court also looked at broader duties towards children in the Children Act and highlighted that it was Section 55 that the appeal was brought under, but even under Section 11 of the Children Act 2004, that only applies to the Secretary of State for the Home Department in very narrow circumstances. So there wasn't any recourse there. So following this judgment, how can we secure school places for migrant children? Even if we can't fix the accommodation itself, can we make sure that children are at least getting time out of the hotel in a school environment and being able to thrive as much as they can? So we've got Section 19. I have managed to delete the Act, but it's the Education, Ollie, what is it?
Education Act 1996.
Education Act 1996. Yes, so the wording is that each local authority in England shall make arrangements for the provision of suitable education at school or otherwise than at school. And the statutory guidance makes clear, I've got the citation for the guidance there, that this duty applies to all children and young people who would normally attend school, even if they're not on the roll of a school. So they don't need to have ever been enrolled. So in the case of Manchester, if they hadn't yet been enrolled in Southwark and were moved to Manchester, Section 19 still bites, and the local authority still had a duty to provide either education or education at school, otherwise than at school. I've got a report here from 2022, which is looking at the quality of education that can be provided otherwise than at school, so within the hotels, and it's clearly not suitable. There's an issue with who's actually responsible, particularly for unaccompanied asylum-seeking children who are in bridging accommodation in hotels, because the Home Office isn't acting as the corporate parent, and they're not technically looked after by the local authority either. And there's no way that the Home Office said that they can cater for that gap within the hotels. So it does seem that it will have to fall on the local authority. The Refugee Council produced a report in April 2021 that also highlighted how inappropriate it is for education to be conducted in hotel rooms, thinking about 2021 online schooling. The Wi-Fi wasn't strong enough for children to log on to their lessons. Whole families are contained in one bedroom, and they might have children in different classes at different key stages, all distracting and interrupting each other. So it's not productive, and it's clearly not suitable education. So this is the strategy that I propose, bringing challenges under Section 19 to make sure that we can secure education for children who are accommodated in hotels. So first, request the education under Section 19 and refer to the guidance to remind the local authority that the child doesn't already need to have been on a school roll in the area for Section 19 to bite. Point to the evidence which I've cited there, and you will have on the slides, that indicates a hotel room cannot be suitable education. So just giving them a textbook and an online tutor and expecting them to conduct the education in their hotel room will not fulfil Section 19. And if they don't secure a school place, then send a nice pre-action letter, and hopefully we will secure a place after that. Long game is to make sure there is suitable education for children accommodated in hotels. And with that, I'm going to pass back to Steph. Thank you.
So we're now, for our final speaker, going to hear from Ravishaan, who I said works as the Communications Director at JCWI, and within his remit to focus on campaigns against the many ways in which asylum seekers face discrimination and destitution. And obviously we recognise that identifying the problems, thinking of legal solutions in this particular juncture is not enough. That it's critically important that we try to engage in advancing an alternative narrative to the one that the government is peddling, particularly insofar as it does have so many connotations, xenophobic and racist, the kind that we've talked about that's been picked up in the context of other forms of discrimination. So we're really very keen to hear from what you've said and from your experience and what you can tell us about how that narrative can be challenged. And I think it says here, and I don't think this is wrong, is that we're ending on something that will also give us some inspiration and some hope in times that are quite dark.
Yeah, I hope so. Firstly, thanks for having me. My name is Ravishaan Muthiah. I'm the Communications Director for the Joint Council for the Welfare of Immigrants. I'm not a legal person anymore, so I feel like I've learned a lot today. I'm not exactly sure what I've learned, but I've learned something, and I've taken some notes. So for those that don't know, the Joint Council for the Welfare of Immigrants is a charity. We've been around for 50 years. We've been fighting for the rights of migrants. We've been doing legal advice, pushing back and challenging the negative narratives around migrants, and pushing for policy change. Today, I want to tell you a story, really, a few stories. Firstly, I want to start with a story that's quite close to me. So we're going to present the human side of this discussion. So I want to tell you about Sri Lanka in 1983. Some quite horrific pictures up there, so maybe I should have given a trigger warning. But Black July was a pogrom. It was an escalation of mass violence against Tamils in Sri Lanka. And it led to many people being put into refugee camps on the Paradise Island of Sri Lanka. My grandparents, who owned a printing shop in Sri Lanka, which was Tamil-owned, it was burnt down, it was burnt to the ground. So they were forced to stay in the UK. Their brothers and sisters were in refugee camps. They had very little, but they knew they couldn't move back. They had to stay in the UK for the safety of their family. So at that time, it was much easier for people to do that. The country was much more welcoming. They were able to start a life. They were able to have a life that flourished, and actually led to me being in this very room today. So it was a success story. But today we know that that isn't the case for those people that want to seek safety and seek sanctuary in our country. Firstly, they have no safe routes to arrive here. Secondly, if they do arrive here, they're demonised by our media and our politicians. And finally, where do the government house these people, which is the topic of our discussion today? We know they can be housed in, hotels like Knowsley, which we know had that massive far right attack. They could be housed in barges. They could be housed in private accommodation or detention centres, none of which are anywhere we would want our families or loved ones to stay. So it's a horrific situation. And most of the clients that we work with at JCWI lived in shared housing. Now, when I first heard of this, because I'm, again, not a legal person, I thought shared housing doesn't sound too bad. I mean, we've all lived in shared housing at one point in our life, whether it was at uni or sharing with roommates at some point. But this isn't that sort of shared housing. There's none to little privacy in these housing. Housing managers regularly intrude and cross boundaries of privacy. And people who are already traumatized by those very breaches of privacy are then re-traumatized. They're left wide awake through the night, alert and praying that someone, a stranger, doesn't open their doors. So one of our clients, who was very vulnerable, was attacked twice in the night by another person. They ran away after being attacked. The police then picked them up, took them to another hotel. That hotel then didn't have them. They were left out homeless in that night, which is an absolute disgrace. Another one of our clients, a pregnant woman who was housed in a hotel, she missed 2 really important medical appointments because her hotel, which is obliged to pay for her medical appointments, failed to. So then her doctors and nurses were forced to provide money from their own pockets to enable her to go to those appointments. Another thing, the food in these accommodations is dreadful. She was given really spicy food, and for a pregnant woman, this was really dangerous for her. She didn't like the spicy food. It was really bad for her stomach. So her doctors and her nurses said, stop having it. So when she said that to the hotel staff, they said, okay, we'll give you biscuits. This escalated even further. She lost an extreme amount of weight at 35 weeks pregnant. Anyway, she's given birth now, which is good news. But the bad part of it is her food has been changed now to a kids' meal of chicken nuggets and chips. It's just not right. So what's going on here? The media tells us that the government is spending 6.8 million a day housing asylum seekers. So where's all this money going for this abysmal service that we've just discussed? Serco and Clear Springs are swallowing up how many millions of profit, while the government tell us that asylum seekers are to blame for the taxpayers' costs. So something's not right. What's happening on the ground? This is what's happening on the ground, and this is the reality for asylum seekers. But what does the government say? Well, we know what they say. They say there's an invasion. They say they dream of deporting people to Rwanda for Christmas. What sort of a sick dream is that? And then they say that asylum seekers and migrants are draining our resources and we have to stop the small boats. So not only do they say this, but then this is parroted by the media, news channels, and across tabloids. And just last week, the tragedy of Greece saw, up to 100 people who have died so far. There was no international rescue mission. There was no massive international media attention, maybe a day's worth of media. Then yesterday, a submarine with 5 billionaires or millionaires went missing. They're both tragedies. They should both be covered. But that was massively covered. And there's a massive international rescue mission going on for it right now. So it's clear whose lives are worth more to the media and our political class. So maybe this is the inspirational part, because that's all a bit depressing. So how do we combat this onslaught of hostile media towards our clients, which comes from the very top? Well, we look at the facts, which firstly, the majority of people in our country are very welcoming. A recent poll, which polled 29 countries across the globe, showed that the UK was the 3rd most welcoming country. We need to make sure that when we speak to the media, which is my job, we centre our messaging around commonalities, like community. We've all likely grown up with migrants somewhere in our lives, whether that's local businesses, at school, university, or the workplace. We all have positive relationships with people that have moved to this country. And we know from the Ukraine scheme that people are very welcoming. They've opened their houses to people that are fleeing war. So to combat this hostility, we use these stories like some of the ones I've told today, but also those that connect to you and I and cut through the demonization of migrants that we know is plainly false. But what happens when the government doesn't act in line with the will of the people? We're saying that this is where the rich people are, but the government don't seem to care much about that. What happens when the opposition shows no immediate signs of repealing their laws or changing? So what good is communication strategies like this when the government aren't listening? Well, this is where campaigning as a whole comes in. Communications won't win us the world. Yes, we need to challenge toxic narratives and poison. Yes, we need to speak truth to power and cut through the noise with human stories. But we won't win purely by doing that. So what we need to do is we need to combine policy work, we need to have the policy solutions, we need to combine some of the legal work that we've spoken about today and ensure that we're winning those cases on a legal basis. So how do we do that in practice? How do we ensure that communications, advocacy and legal work is all in one? To give a recent example, a few weeks ago we publicly challenged the government's proposal to remove HMO licence requirements for asylum seekers. This has a massive risk to housing safety and the basic protections we all deserve. It could mean landlords could rent out houses which would have no basic fire protections, which would have faulty gas or electrical appliances, and there could be massive overcrowding as well. So we came together with 136 housing and migration organisations. We sent a letter to Michael Gove and Ceallaigh Braverman, asking for them to abandon these policies. The story was front page of The Guardian, so it did well. So in terms of the comms and the advocacy, it did well. We're starting to pile on the pressure on the government. But still, there's not much room, there's not much budging. So the next thing that we're going to do, the next tool, and I can't give too much away because my legal director will be very annoyed, the next tool is the legal route and trying to push further through the law. So through bringing all these elements together, we can push back even when we have the most hostile government, the most hostile media. So yeah, I hope through this short presentation I've been able to convince you firstly of the power of stories, how they can bring you in, how they can sort of communicate a lot more to people. I hope that you've understood as well that it's all of our jobs to push back against this government and their hostility. We need to provide policy solutions, we need to challenge the divisive narratives, and we need to use the law to win individual cases and make legislative changes. So the world I want to live in, finally, looks a bit like this. It doesn't include Ceallaigh Braverman. It doesn't include Rishi Sunak either. All their hostile laws, all the language that they use, it welcomes people who are seeking sanctuary. And it doesn't include such a massive fight for all of us in this room to try and achieve the basic human decency for fellow people that are coming for safety and sanctuary. So yeah, I hope that we can all continue to come together and to fight for a better world for all. Thank you.
Thank you very much. I think on that front, my introduction was accurate. You had some errors on other people. So we have some questions for people who are online, which I'll raise those first, and then we'll open up the room. We're running a little bit late. For everybody here, there is going to be drinks and some food afterwards, so I hope you will stay for the questions, and then we can carry on the conversation after the formal part of the proceedings is concluded. So there was a question, or there was some information in the chat that talked about the barges. So one of the things that was identified, the person didn't put their name, but they said that in terms of this question of quasi-detention, that the arrangements that are going to be made for the barge is that you have to remain on it. You have to exercise within a particular compound that's on the port. You can only go off site via a shuttle with buses that will be specifically laid on and paid by the Port Authority. So it seems that outside of those specified abilities to leave, you won't be able to. So I don't know if that's something that you've seen information about that.
Yeah, I mean, the fact sheet is on the Portland Port website does say something along those lines. Yes, exactly, that buses will be laid on. so you only presumably be able to go at certain times. It raises a question for me, I mean, lots of questions in particular. What about medical care and who is allowed in? Like, what if you need a doctor? What if you need a dentist? What about mental health care? You know, who's allowed in? And
A friend.
how will they get? Yeah, exactly.
Yeah. I don't know, Greg, looking at that from the experience of the Penally and Napier litigation, the issue of the constraint on people's liberty and whether it constituted false imprisonment, what do you think about those arguments? It's a difficult argument, but
Yeah, I mean,
that kind of factual scenario.
I've been looking at that, and it was something I've been thinking about actually. And I don't think we know enough about the facts yet. I think you're going to struggle on, probably, I suspect you're going to struggle on false imprisonment. I mean, unless there's a total. Well, it's just going to depend how they enforce it. I think on what I've seen so far, it's more likely to be an Article 5 issue. I would think it's more likely to be deprivation of liberty than there to be a total limitation on people's ability.
I'd be a bit more optimistic about the common law.
Yeah.
On constraints, you don't have to have. It doesn't have a prison with walls. I think. It's I suppose it's what's the sanction. There's two questions in there. What's the ability and what's the sanction? So I think the false imprisonment might actually be more likely to succeed than a Article 5 because of case law on Gazzardi and all those cases that you can be constrained in a curfew type situation. You'll have to look at all the conditions, but I mean that's something that people need to look at when we get closer to the facts.
Yeah, I mean I suppose it comes to a point where you want to leave a place and they just won't let you.
Yeah,
but I think you are looking at a proper false imprisonment kind of scenario. Whereas if they end up saying something like if you leave here you won't be let back. That's not going to be false imprisonment, but it might be.
Okay, so definitely that's something that is going to be a significant issue. And the second issue, which again related to the barge that was raised by Nicola David, she raised the fact of the contractual arrangements that were agreed through a tender process that in fact didn't take place. So as with what was happening a lot with COVID, they abandoned all the tendering processes and obviously just had the criteria of are you my mate. I don't know if anybody at CTM and the travel company is a mate of somebody, but the bottom line, according to the information that Nicola has given, is that there was no proper tendering arrangement. And I suppose that would be another aspect of the ways in which basic regulatory frameworks are being abandoned within these introductions. And again, I don't know if that's something that's come across your desk at all yet.
Yeah, I mean, that's really interesting information. And I mean, I'd never heard of corporate travel management before. It seems like the Home Office, I mean, what they've said publicly about it is they've done a fantastic job on, in Scotland with the refugees there. So we're going to use them again. But obviously, this is a bit of a different situation. I'd be really interested, and maybe it's worth us exploring, doing either a freedom of information request or a parliamentary question or some kind of public request for this kind of information. And what involvement they'll have. I mean, we don't know if they're going to be the people who are on board the barge dealing with day-to-day operations. Will that be somebody else? Will they have gone through a tender process? How are they qualified to do it? There's all sorts of issues, but maybe we should be asking public questions about this and coming together on that.
Yeah, and apart from telling us, Nicola's come back and said it is in fact a mate of Boris. I don't know if that's true or not, and whether they've got a knighthood coming their way or something like that. But the serious question that's raised is about legal challenges to contracting processes. And I don't know if anyone wants to comment on that. Obviously, there was a legal challenge to the way in which the contracts in COVID have been handed out, and some of them were successful and others not. Yeah, so I think that in principle, it's something definitely worth exploring, and I certainly can say that it's been a theme of all of these different forms of accommodation, whether it's hotels or it's the Penally or a Napier Barracks. They are not really properly compliant with planning permission. So even now, when they are housing children in unaccompanied asylum-seeking children in hotels. They haven't changed the user in planning permission from hotels to now effectively unregulated children's homes. There's no attempt to change the planning regulations. In Penally, they never had appropriate planning permission. They had some extension. There was some talk about the Welsh Government actually challenging that it was due to come up to expire what they had. And actually, when they abandoned using it, I don't think it was the only reason, but it was partly because they would need to have actually gone through a proper planning process, and there was widespread opposition in the local area. So I think it is a really important thing to look outside of our human rights dimension, look at the granular protections that there are. And it seems that, I think you've raised a really important point about this being a particular context where otherwise there may be very detailed provisions that cover minimum standards for this to be an acceptable place to reside. So those were the comments from the social from outside. I don't think there's any others. No. So if anyone else in the room now would like to raise a question or make a comment, we're all ready. Elspeth.
Hi, Elspeth from Medical Justice. We mostly work with people in immigration detention, but we're also doing quite a lot of work around quasi detention sites. For example, the Barge. I'm working a lot with Nicola actually. This might be totally false hope, just on a possibly hopeful note maybe. I noticed that one of the by-elections coming up that the Tories are going to be facing is in the constituency next door to the Barge constituency. And just linking back to the Penally example, I think one of the factors, I remember from worked on that, one of the factors that kind of influenced the government's decision around that was the fact that there were local elections coming up in Wales. One of many factors, I think. Anyway, just kind of linking the two together, maybe there's scope there possibly to delay a little bit the Barge, if there's work kind of at the local level, putting pressure on the local candidates to kind of come out against the Barge. I don't know how much influence or how much kind of people in that constituency care about what happens in Portland, but maybe worth a shot.
Care about the money as well, wouldn't they? I mean, I'd really be interested to see an analysis of what kind of accommodation you could get people for the cost of putting them up in the Bibby. I suspect you could put them up in the Ritz. I wouldn't be surprised at all if it's something comparable to that. And I think the more things you can do in terms of, like Muthiah was talking about, looking at the regulatory issues, I think the more digging in that's done into the finances and the money, I think the harder it's going to be to justify it. I mean, it sounds almost straightforward, like a rationality issue when you come to the sheer cost of it. I think I find it hard to believe that this is going to be a long-term thing, because it's just going to be an absolute money pit. And things are going to go wrong, and they're going to cost money, and there are going to be claims, and they're going to cost money. So I think that's right. I think you do need to look at the political angle, and it could very well be that it's really affected by the factors of by-election. The thing I'd worry about is what the nature of what people are saying about asylum seekers in that by-election is going to be. So I wouldn't be super optimistic about it based on a survey I saw of attitudes of people in Portland to asylum seekers.
Yeah, I think that would be one of the double-edged issues, that the cost, it would be used as a main basis for saying, well, these people are costing us so much money. That's the agenda that the Home Office, that the Labour Party wants to pursue in Parliament. They were prepared to object to these policies on the grounds of the costs and practicability rather than in principle. But I don't know, Rav, how do we turn that around? Obviously, we can say, it's not the responsibility of the people who are coming here for these increased costs, because they're making the decisions. But I mean, I don't know how you sort of feel we can best engage in that debate.
I think in terms of like engaging with local communities and explaining the situation of people that are moving to this country, the thing that, again, like I probably covered in the presentation, we have to really bring it back to the fact that we all have many things in common, and we all have the fact that we need to survive in common, and we all have the fact that the government are using migrants at the moment as sort of political football. They're throwing everything at people that move, but actually it's not people that move that are causing the problems that people are facing in their local communities. It's the government. It's Liz Truss's budget from September, which is creating a cost of living crisis, which is leading to spikes in inflation and so on and so forth. So it's, retargeting and recalibrating people's anger and rightful anger at the state of the country, rightful anger at the state of the NHS, rightful anger at the state of the economy, recalibrating that towards the people who are to blame, which is the government, which is the sort of big corporations who are not paying their taxes and so on and so forth. So that's what we need to do. And through that messaging, we know it works. That's the other thing. We know that people don't want to be angry with other people. We wake up every day and we meet other people. We don't want to be angry with each other. We actually want to get on with each other. So it's much easier to tell people, you're not angry with the people that are in your community. You're not angry with the people that you go to work with. You're angry with people that are making your life harder because of the economic decisions they're making. So that's what I would say, yeah.
Okay, thank you. I think, would you like to?
Yeah, Lisa Matthews from Young Roots. I was just wondering about the potential for legal challenges on behalf of individuals who are in asylum accommodation, unsuitable accommodation like this, being used for more systemic changes when we saw the issues with, and obviously you're trying to get your client out of that accommodation, and so what happened, and the good result for that client is they get out of the accommodation, but then that never leads to any form of systemic change. And I wonder if there are any lessons learned from that experience before that we can think about this time round.
Yeah, I mean, there were a lot of difficulties with it. Ultimately, a challenge did get going, though. I mean, if you have a practice that's affecting lots of people, I mean, the Home Office will try and crush challenges by sorting your client out. But if the same thing's happening again and again, eventually you are going to be able to say that your client is not academic, it needs to be considered in the High Court. Tactical questions arise over whether you try and keep it in the QBD, in the Queen's Bench Division, which primarily deals with damages claimed, or whether you can keep it in the Administrative Court where you can get more public law remedies. Ultimately, I think what will happen with these cases is that people will bring generic challenges. A charity with standing will bring a challenge, or somebody, an individual will bring a challenge, and either it won't go academic or it will go academic and they will make an argument that they should be allowed to continue anyway. I think that's ultimately the NB and others, isn't it? Yeah. They're all it's all academic by the time they were considered. And you just have to factor a bunch of things into account. So, like, for example, if your client has a really strong damages claim, they may not want to take the risk of getting involved in some systemic litigation, but on the other hand, sometimes some of them will. They'll be angry enough about what happened to them that they will want to keep going. So you have to, when you're thinking about strategic litigation, you have to balance a bunch of factors. You have to take into account your client's best interest, obviously, and you have to find a case that works. You don't want to go on bad facts, but you have to remember as well, these cases aren't our cases; they're our clients' cases. So, but ultimately, I think there will probably be a challenge if the Barges thing goes ahead, which it probably will. There will be charities planning to take challenges, and they will. There will be individuals affected who will take challenges, and probably their facts will be broad enough that they will be justified, or they will be representative enough that they'll be justified in continuing, even if they've been transferred out, and probably a lot of someone will want to. So those things will kind of sort themselves out, I think.
If anyone else wants to comment on that?
I think there's an important point about cooperation and coordination around this, because if the Home Office picks off all the good facts and leaves you with the less attractive claimant, that's unfortunate. But you can have case studies of other people to put the full range of facts before the court. So sort of having a coordinated effort of like collaboration between NGOs, and law firms, so that even if the claim settles, the case study can still be sort of recorded, and the sector is really good at working together to collate and gather all that evidence together behind a systemic challenge.
It's also worth saying, people often think that, we're always called campaigning lawyers, or, courts often say that we're engaged in strategic litigation. The Home Office does strategic litigation. They pick the facts. They get to make the law and pick the facts, So they'll always have an eye as to which cases are the strongest ones, and those are the ones they'll try and pick off, and you just have to try and work your way around that.
I think that we should be thinking about using civil claims, because there is a hostility to generic litigation. I think a number of the issues that we've talked about are susceptible to generic litigation. That's certainly the case in strategic litigation. But actually, the High Court King's Bench Division can also issue declarations. And the benefit of those cases, you don't have to get permission. They're much more familiar with injunctive relief, because that's what's happening all the time in the civil courts. And you get those people who've made these decisions to have to come to court. They don't hide behind their witness statement if they bother to put one in at all. They have to come to court, and they have to justify what they've been. I think they've got to have duties of disclosure. Disclosure are very important in these contexts. All what are the arrangements? What's the contract? They will resist that in judicial review, and so you've got much more proactive disclosure obligations. The court is used to having a much more intensive requirement for disclosure, which is important to get to the root of what's going on here. And then, of course, they can be cross-examined, and that would actually, I think, in the issue to do with the detention or the quasi-detention, if they were cross-examined, I think you would have got the answer out of them that, in fact, they knew that the contractors were telling people they had to remain in, and that the curfew was a requirement, because that is what was going on. But they can hide behind these; they're not pinned down in a witness statement. So I think it's not the only remedy, and we've got a well-established experience of bringing litigation in the administrative court, and it's more naturally is the place where that's been done. But I think in other times, especially in detention contexts, the challenges to policies on detention of children, a lot of those were done in the King's Bench Division, and so we should be thinking about that as another route. And certainly, if you've got your client out and you've got that remedy, so you can't go to the High Court Administrative Court, look to follow up with making them actually pay for what they've done, and make them have to justify the individual decisions and not just strategically drop you out because it benefits them. I think that's a really important message to come from what strategic litigation can also do, other than just in the administrative court. So, do we have any other questions? Okay, well, I hope that you found the spectrum of consideration of the different ways in which the Home Office, I think, is using what might be described, I think, by Greg as its stupidity and its incompetence, but also what we also have heard, its punitive and pernicious strategies for dealing with asylum seekers. And certainly, I think that a theme that came through was that there is very much here a context of responding to whipping up of xenophobia, whipping up of anti-migrant and racist sentiment. And it's very, if you can locate it, if you look at the Home Office's equality impact assessment for Napier and Penally, they basically said in terms they were responding to this whipping up of anti-immigrant feeling by Barrage and others by saying we need to provide inferior accommodation to these people because that will ameliorate the opposition that there is. So it said it in terms. There's no question that was a response to racism and to choose to provide inferior services to this particular targeted group of people, with the consequence that they obviously were in wholly inadequate accommodation and surrounded by people who were following up on the far-right racist agenda that had triggered the use of this in the first place. And so that certainly is something that is at the core of a lot of what is going on here in a wider level. It does actually mean that, that's the big picture. It's very difficult to litigate that, not least because I think, as you said, Ollie, that the public sector equality duty and the exemptions that immigration control has empties out racism. It focuses only on colour. That is a factor, but it does make it much more difficult to challenge that. And of course, it's generating opportunity and focus for discrimination rather than the Home Office itself doing that, so which makes it very difficult to challenge. But that is the big picture. But it seems good as strategies as lawyers to get down to the nitty gritty. And I think Joe's given us a fresh way of thinking about how are we going to look at these challenges. And there certainly is a lot of scope for getting down to basic regulation, because if they haven't removed it, like they have done, for example, for 16 and 17-year-olds, they've removed the requirements for there to be particular levels of authorised accommodation for 16 and 17-year-olds, registered place premises. They remove those regulations, so they've deliberately removed the protections that there should be for the accommodation of children over 16. But they aren't doing that. They aren't systematically removing all the protections. They're obviously trying it in some respects in other kinds of accommodation, but they don't seem to have done it yet in the context of barges and maybe other forms that they come up with. So I think that is really important for us to look at that. One issue that wasn't raised is legal access to legal representation. All of these forms of accommodation make it extremely difficult to access accommodation, not just because of the access lawyers, not just because of their physical constraints, but their locations in a small village in Wales, in Dorset. We struggle with access to legal representation in London and large cities. Who the hell is going to be able to provide access to justice when you're there? Get your doctor to go and see them if there is an issue about trauma and mental health problems. The practicality of running challenges is extremely difficult. But I think the one thing that it wasn't also an experience is that where those places were used, like in particularly, I know from experience in Penally, whilst there was far-right racist protesting and intimidation and harassment, there was also a very strong local community in support and who were welcoming and who provided blankets and clothing, because those people didn't have them. You know, they were outside in the snow for getting their food, and they had no winter clothes. It was, the Red Cross was coming in, as well as local people donating basic requirements like clothing and toiletries that they just didn't have access to. So we can only see that we have to have, as Rav so clearly said to us, we've got to have a human response to systematic policies that are inhumane and dehumanising of this particular highly vulnerable group of people. And that's what gives us our hope that the inspiration that did come from the legacy of the Refugee Convention and all that it did mean in international law can still be a beacon for a legal principle that we can implement in daily lives by recognising fundamentally that this is inhumane treatment of human beings and intolerable and intolerant. And we stand together to challenge it in whichever area of work we find it, whether it's as a lawyer, as a campaigner, as an academic. We've got that common theme that unites us in Refugee Week and hopefully in all weeks beyond that. So that's really bringing the discussion to an end now, but I hope that it can continue on a different individual basis. We can go downstairs and have a drink, have something to eat, and can I say thank you very much for attending those and online. Thank you very much.